This is Charles Chapman with Remax Realty Services. I'm with Cecilia Adams, who's an excellent and highly regarded settlement attorney with RSI Title. Cecilia is going to tell us the do's and don'ts when using a power of attorney for a real estate transaction.
Hello, I'm Cecilia Adams with RSI Title, and I'm going to be talking today about out-of-town clients using a power of attorney or a mail-away package for closing. So what is a power of attorney? It's a written authorization to represent or act on another's behalf in private affairs, business, or some other legal matter. The person authorizing the other to act is called the principal, the grantor, or the donor of the power, and the one authorized to act is the agent or the attorney in fact. There are two types of powers of attorney, specific or limited. The limited is usually used for a specified act or type of act, typically used for real estate transactions. And the general allows the agent to make all personal and business decisions. Keep in mind, this is a powerful document and not to be taken lightly. Be sure to use all precautions when using such a document. Who may grant a power of attorney? Anyone? No. A person acting in a fiduciary capacity may not grant a power of attorney. So what does that mean? A personal representative of an estate, a trustee of a trust, whether revocable or irrevocable, and you must also consider mental capacity, such as dementia. If dementia is involved, there's always a concern that the principal may not have been competent at the time of the power of attorney was executed, and it may require an affidavit from a physician or court-appointed guardian. Keep in mind that an alive and well statement is typically required at closing, which means that the person that granted the power of attorney is still alive and well. So what to do if you have an out-of-town seller? You must immediately notify the title company. The seller may sign in advance. The preference is to use a mail-away package if the seller is not available to sign in advance and not using a power of attorney. Keep in mind, a real estate agent should never be an agent for a client using a power of attorney. An original power of attorney is always required and must be recorded. The title company is also required to speak to the seller and inquire why they cannot attend closing. If a power of attorney does exist, do not assume it is okay for real estate transactions. It must comply with jurisdictional requirements, and things like the language used, the age of the power of attorney, and the notary must all be validated. So what is the proper signature if you do have a power of attorney? Here's an example. Sam Seller cannot attend closing and decides to use a power of attorney. Sam Seller is the principal. He executes a valid POA naming his friend, Freddie Friend, as his agent or attorney in fact. Freddie Friend signs the document using the POA as Sam Seller by Freddie Friend, comma, his attorney in fact. If they're asked to initial a document, it would look like SS by FF, comma, AIF. So using a seller mail-away package, how does that work? Well, the title company will email or overnight the documents to the seller. The seller will take to a notary and have them signed and executed. We always recommend that copies are faxed or emailed to the title company for review. Then the seller will overnight the documents with a service using a tracking number, such as FedEx or UPS. The seller proceeds can be wired to a domestic bank account, and it must match the seller's name. The seller should be available during the closing for any last-minute issues or adjustments necessary. And what happens if the seller's out of the country? You must allow additional time for the documents to process. The documents must be notarized by a U.S. notary. It is recommended that well in advance an appointment is made at the U.S. Embassy or the consulate. The seller proceeds can be wired only to U.S. bank account. And often, we sometimes can limit what is sent to only those documents that are going to be recorded in the land records. So what if your buyer is not able to attend the closing? If they're paying all cash, it's usually no problem. We could just use a mail-away package. But if they're getting a mortgage and there is financing, it will require lender approval for use of a power of attorney. The power of attorney must be specific with the loan information, and it must be original and recorded. Keep in mind that Fannie Mae recently issued specific guidelines and requires a written statement from the borrower. A mail-away package for loan documents typically cannot be used because the signing date must match the actual closing date. I hope you found this helpful to you, and if you have any questions, feel free to contact me.
Thanks, Cecilia. That was very helpful. Cecilia is a great resource for any of your real estate settlement questions, so feel free to get in touch. She'll be happy to help.